Today, in the United States, students are entitled to an oral or written notice of any charges they're facing before they can be suspended from any public school for up to 10 days. In the case of Goss versus Lopez in 1975, students were suspended from school during a protest hearing that occurred without having their rights read to them or any public hearing. Some of the students claimed to not be part of the demonstration, which led to their lawsuit against the school district for violating their student rights. The case was appealed all the way to the U.S. Supreme Court. In the ruling by the Supreme Court, it was determined that students have the right to a hearing, even if it's informal, to explain the purpose of the discipline and to allow the students an opportunity to state their case before they are determined their discipline. In order to gain a better understanding of what occurred in the case, we will give you a couple different examples of what to do and what not to do.
What are you doing?
We didn't even do anything, dude.
What are you guys doing? What is this?
We're just painting, dude.
No, put your paint down.
Just trying to paint, dude.
No, you're suspended. All of you. What are you guys looking at?
This
You're gone too.
ain't even fair,
We
man.
didn't even do anything.
Out of here. 10 days, I'll see you later.
Really?
You know what,
You
man?
suspend us for nothing?
All of you.
We're just standing there.
You know what, man? I'm the president, man. I'm
Bye.
the president, and that ain't fair,
See you
man.
later.
It's not even fair.
The teacher did not handle the situation in the most convenient or effective way, which can lead to more stress and more drama to follow in other scenarios. What you'll see next is when an irate parent comes in to deal with how their child was suspended.
Let's go, sit down. Hi, I'm here to meet with somebody about a suspension.
Yeah, I'm the principal.
Oh, hi,
Hi, nice to meet
I'm her
you.
mom.
So about the suspension, yes, sir.
Yeah, what's up with that? She tells me there was some kids painting and she was just watching.
Yeah, she was watching, and
Okay, so she didn't do anything and she's suspended? What's up with that?
I feel that's encouragement, and we say guilty by association. She was there watching, and
Oh,
I
no.
took the whole group out.
That doesn't work for me. I think I'm gonna take this to the school board.
Okay, they meet on Tuesday. 7.
Excellent, see you there.
Okay, thank you.
There are other ways to solve the issue. Before jumping to conclusions, maybe the educator could have taken a more appropriate approach, such as in this example.
You guys are painting the walls of the school. Knock it off. What are you doing? That's enough. That's enough. You guys all need to go to my office, and I'm going to get your statements from each one of you guys before we make parent phone calls. You guys
I didn't do anything.
You guys
I
who are
didn't do it.
I understand, but we're still going to get a statement from you before I call your parents.
We didn't do
Everyone to my office.
When an educator holds a hearing with a student about the matter that came place, it allows both parties to state their claims and gives opportunity to see if a resolution can be made in a more appropriate and effective manner.
So you guys were in there and you were painting the walls of the school, and that's definitely against the rules. What do you have to say about it?
I felt like painting and he said it was a good idea.
Do you believe it was a good idea?
Yeah.
And what were all of the other students in there doing?
Painting?
Okay, I'm gonna take your statement and I'm gonna write it down, and I will be calling your parents, and since you were one of the ones painting, you will be suspended.
Okay.
In the book School Law and the Public School, Essick points out how we can protect students' rights through due process. You must tell students about the charges prior to just suspending the student. A hearing must be had. The hearing doesn't have to be formal. It can be very informal, but there has to be some sort of communication. They have the right to legal counsel if the event has reached that particular point. And the hearing has to be for someone who's impartial. In many cases, that means that it can't be the party that's involved in the scenario in the first place. And they must have the opportunity then to have witnesses that can attend to and compel to meet the needs of their situation. And they can talk about themselves and testify on their own behalf. And then usually the best scenario is always to document the situation. So what can we learn from this? Well, there's a certain guideline that can be stated for all school leaders. First, we obviously have to be fair and focus on the process. The process allows the opportunity for students to state their views. The level of that depends on the seriousness of the offenses. In fairness, it isn't always equal, and equal is not always fair. But we must take each scenario and situation as it's each an individual's point of view and move on. The case Goss vs. Lopez established that due process must occur for disciplinary suspension with a hearing, otherwise the student's rights have been violated. The court argued that students had the right to a hearing, even if rudimentary, for students to explain their perspective of the incident that had led to the suspension before discipline is determined.